All right, y'all. I'm back again with another video. Good afternoon. Supreme Litigant. Y'all already know the routine. Before I begin, pound that subscription button and pound that like button. I'll give y'all a second to do that. All right. Thank you. So let me jump right into this. Today, I'm going to be discussing my case. I'm going to click on documents. This is the actual pacer online. I'm going to click on documents and I'm going to explain to you why I filed these documents. You're going to see the documents. I'm going to read them. I'm going to go over them. And you're going to see their responses to the documents and so on and so forth. There's a lot of stuff as far as like when we were going through discovery, those documents, you really won't see them on the docket. They were done privately via email and via US mail. But the rest of the stuff you should see, except for the non-disclosure agreement, you won't see that because that was done privately. You won't see the terms and conditions. Well, you won't see anything that had to do with the settlement. You won't see it except for the court order proving that the case was settled. These are the. This is me. This is my name or whatever. This is the one of the defendants I've sued. The second one, and there was a third one, which is him. I couldn't find him though, so I just didn't worry about it. But the other two, I got them. So this is my complaint right here. And when I click on this, just relax. I'm gonna try to break everything down to you. This is 4 pages long. My complaint. My complaint was short and just straight to the point. Okay, so let's get this done. I filed this January 27, 2021. If I had waited probably about 4 or 5 more days, maybe 6 days, my cause of action would have been barred by statutes of limitations. So, if you don't know how to litigate this case or draft this complaint, this video is for you. And all the other documents, if you want to know how, this video is for you. So the first thing, if you don't know your rights, then you don't have any rights. You need to know what your rights are. And the only way that you are going to know what your rights are, you are going to have to read cases. And you're going to have to read until you just get tired of reading. So most of this stuff, like the jurisdiction and venue, the party section, that stuff is just boilerplate. I mean, you would go in, you would make your edits wherever you needed to make them. For example, right here, Mobile County, Alabama. Of course, you will obviously change that to your county and your state. Blah blah blah. The defendants, wherever these police officers worked, for example, let's say your defendant name was Michael Smith, and he worked for the Atlanta Police Department. You would say defendant Michael Smith, hereinafter Smith, at all times relevant to the facts herein, was a police officer employed by the city of Atlanta. That's what you would do. Okay. This stuff right here is pretty easy. You can literally copy and paste this right here and put this in your complaint. You would need to edit it. I have 1988 in here. This is for attorney's fees. So if I wanted to later on, after I pretty much done everything, I did plan on hiring an attorney for trial. That was really it. I took care of everything else myself. So if I would have hired an attorney for trial, I would have been able to get attorney's fees pursuant to this statute here because I won my case. There was a settlement, so I would have been able to get attorney's fees from the defendants where their insurance company, because that's who indemnified them. So I would have been able to get basically to recoup the money that I had lost or that I had spent litigating this suit. So it's, in a sense, they're doing some sort of equity here. It's the right thing to do, in my opinion. The Fourth Amendment. This was a Fourth Amendment, cause of action. Also, what you need to know is if they violate the Fourth Amendment, then by default they automatically violate your state constitution, whichever subsection in that state constitution that is identical with the Fourth Amendment. They automatically do that. So it's instead of just violating the Fourth Amendment, they also violate the state constitution too. So let me just read over a little bit of this for you. The Fourth Amendment. This suit is brought pursuant to 42, Section 1983 and 1988, the Fourth Amendment and 14th Amendments of the United States Constitution and the laws of the state of Alabama. Plaintiff invokes the jurisdiction of this court for his federal causes pursuant to 28 United States Code, Section 1331, 1343A, 3 and 4, and 1367A for his pendent state causes. So basically, pendent state causes are causes of actions under the state. So like assault, battery, for example, an excessive force claim under a state law claim is the name for excessive force under state law would be assault and battery. On the federal level, they call it excessive force. So assault and battery under the state under state law. When I say state law, I'm talking about they talking about statutes. Because what y'all are looking at here, this is remember when I told y'all that the legislature is creating administrative agencies and calling them courts, and they are investing quasi common law and quasi equity jurisdiction in these administrative agencies. That is exactly what this is. This is a colorable common law lawsuit. That is what this is, because there's no money. Okay. There are no statutes in common law, but if you read this complaint, there are statutes all through here, and it relates to jurisdiction and venue. There are no statutes in common law. So what they did was, like I just told you, they've created these administrative agencies, and they've deposited quasi common law and equity jurisdiction in here. An action, a remedy at law would be money damages. You are allowed to, in 42 Section 1983 lawsuits, you are allowed to ask for so-called money. And a remedy in equity would be an injunction, something like that. You are allowed to get an injunction and money damages in this lawsuit, in the same suit, 42 Section 1983. You're allowed to do that. An injunction is an equitable remedy, and money is an at-law remedy. So y'all just pay attention to that. But anyway, back to the pendent state causes. Pendent state causes is just causes of actions under the state law and state constitution. That's all it is. That is it. Number 3, venue is appropriate pursuant to 28 United States Code, Section 1391, because the events that gave rise to this suit occurred within the judicial boundaries of this court. So venue deals with which court has the authority to exercise the jurisdiction and adjudicate your cause of action. That's all venue deals with. Venue and jurisdiction, they're two different things. Two different things. For example, all U.S. district courts, no matter where they are, all over the country, have jurisdiction to adjudicate 42 Section 1983 lawsuits. But the way that the courts determine which courts gets to exercise that jurisdiction is based upon where the rights violation occurred. So if the rights violation occurred in Georgia, then you would have to file your lawsuit. It depends on the county. The county. Wherever the county is based on the county. There's a statute. I forgot this. I think it's 5 United States Code 28 or something like that. But anyway, let's go down. That'll be it for that. If y'all have any questions about all this stuff, just let me know. This will be a long video, just to let y'all know. I'm going to try not to make it too long, but it's going to be long. So the facts. The ultimate facts. This right here, y'all, this is the most important part of your lawsuit. This is the most important part. I'm going to pause right there. Y'all see this where it says plaintiff's first complaint? You need to do all of your complaints like this. Because you're 9 times out of 10, you're probably going to amend your complaint. And when you file an amended complaint, you would say plaintiff's second complaint. Something like that. Or you would say plaintiff's first amended complaint or plaintiff's second amended complaint. Something like that so that you don't confuse yourself in all of your pleadings, and so that you don't confuse the court or defense counsel. Back to the facts. All events described herein occurred sometime in the month of February and year 2019. So that's when basically the rights violation occurred. And I'm explaining in these facts section, I'm explaining to the court and to the defense counsel what happened. And all of my facts are relevant to my Fourth Amendment cause of action. If it is not relevant to my Fourth Amendment cause of action, I did not talk about it. Even if it happened or not, I did not even talk about it because it's not relevant. It's not going to prove why I'm suing them, and it's not going to prove that they violated my rights. So I'm not going to talk about it at all. I'm just going to leave it alone. I'm just going to act like it never happened. That's it. Plaintiff was heading home from work when his automobile completely shut off as it was still in motion. Y'all see how simple this stuff is? This stuff is just that simple. It is just that simple. Don't put too much thought into it. Okay, just make it very simple. But you want to say, well, there's a saying that I made. Plead no more than what is necessary. So in other words, say no more than what is necessary. And the way you determine what is necessary is you have to read cases. And you're gonna have to read a lot of cases. You need to read so many cases till it gets to the point to where you don't have to read cases on Fourth Amendment jurisprudence anymore, because this stuff has been embedded in your mind, and you know exactly what you're doing. You know that you're 100% right. When I tell y'all I drafted my lawsuit against these police officers in my head on the side of the road in handcuffs, that is what I did. Because I knew what they couldn't do, and I knew what they could do, and I knew that they had no lawful purpose to do anything to me at all. I'm a stranded motorist. That is not a crime. That is not an offense. So, let me give y'all something. These facts are your elements. So I'm gonna give you an example of what I'm talking about. So let's say if I wanted to prove that I was unlawfully detained, then these facts right here prove on how I came to the conclusion that I was unlawfully detained. So pay attention. I'm gonna focus on these facts right here. About 14. We'll get about. No, we'll stop. We'll go to. I'm gonna rely on 13 through 17. Plaintiff then gets out of his automobile and turns the bright light from his cell phone on to warn oncoming and ongoing traffic of the hazard. About 5 to 10 minutes later, a Chickasaw police officer by the name of Brandon Breland flashes his police lights, stops his patrol car, and then exits scene. Breland then walks over to plaintiff and requested plaintiff's ID. Plaintiff then replied, "For what? I knew I didn't do anything wrong, so what do you need to see some ID for? Because you only do that when you have either reasonable suspicion or probable cause, or in a consensual encounter." See, he think I didn't know that, but I know all of that stuff. Breland then replied, "Because you're broke down in the middle of my highway." That is not a crime. As soon as he said that, in my head, I didn't say this out loud, but in my head, I reasonably concluded that I was not lawfully required to give him any ID, because that is not a crime nor offense. Does that make sense for y'all? Plaintiff declined to give Breland his ID, but did give Breland his first name. Breland then walks off and calls for backup. That's what he did. About 10, 15 minutes later, two more officers by the last names of Holyfield and Doe of the Chickasaw Police Department arrived in their police cars. Doe was a male about 6'3" to 5'6" in height, weighed about 230 pounds or more. Y'all see how simple this stuff is? This stuff is simple. You just have to know what to say and know what not to say. This is very simple. Now I've already made the allegations in this complaint that prove that he had no lawful purpose to ask me for my ID, and that's these facts right here. These facts right here, these are the allegations that I make. The judge would rule on these facts to determine if that was a lawful request that police officer gave me. If these facts were not in dispute. Okay, but if they're in dispute, it goes to the jury for the jury to decide. So let's go down. Let's see. All right. There's this time, all three of the police officers approached me, and I'm going to explain to you with these facts how I reasonably concluded that I was detained. Okay. Plaintiff then Plaintiff was then approached as his back was against his automobile. I want y'all to visualize this in your head, okay? Visualize this as I'm reading it to you. Plaintiff was then approached as his back was against his automobile, surrounded by Holyfield, Breland, and Doe, and demanded to show his ID once again in a more aggressive tone. Plaintiff then saw an officer with his hand on his gun, and at this point was certain he was not free to leave, because a reasonable person would conclude, based on all of this, that what he just saw right here, based on 22 and 23, a reasonable person would conclude that he is not free to leave. A reasonable person would conclude that. Plaintiff then replied for what? Plaintiff was then grabbed in an aggressive manner by his arms, as both arms were forced behind his back. Plaintiff was then handcuffed, searched about his person, and then informed that he was being detained. Like I didn't know that already. You see this? Very simple. This fact right here, although it wouldn't be enough to get any damages or so-called money, but this fact right here, plaintiff was then grabbed in an aggressive manner by his arms, as both arms were forced behind his back. That is an element of assault and battery. That fact right there. Because the way you assault somebody, well, the battery is the unlawful touching of somebody. That's basically what a battery is. To assault somebody, you don't even have to touch them. You can just assault is more mental than actual physical. You can assault somebody by saying you're gonna beat their ass. You know, you're gonna beat them up or something like that. You can assault them like that, even though you haven't touched them. If I'm not mistaken, I think I'm 100% right about that. You also want to let the so-called judge know that they didn't have a warrant. You know, they didn't have your permission to do this, and they didn't have reasonable suspicion or probable cause to do any of this. I did all of that in this complaint. That is how I got rid of a Rule 12b-6 motion to dismiss on qualified immunity grounds. When you drafting your complaint, ladies and gentlemen, you need to act as defense counsel for these police officers who you're about to sue, and you need to act as counsel for yourself. Every allegation that you make in this complaint, you need to ask yourself, can this be used against me, or can it be used against the defendants? Me personally, I would not put anything in my complaint that could be used against me even a little bit, unless I knew how to word it and unless I knew how to argue my point. That's the only time that I would do that. If you don't know how to do that, then don't put it in your complaint. Period. Right here, plaintiff was then handcuffed, searched about his person, and then informed that he was detained. See that? That fact right there also proves that I was detained. And if you read all of these facts together and stop right here, all of these facts would lead a reasonable so-called judge or jury or juror to believe that I was unlawfully detained based on these facts. Based on 1 through, well, I ain't gonna say 1 through 26. I'm gonna say, what do they start at? They start at 9 through 26. Okay, yeah. A reasonable juror or a reasonable judge would reasonably conclude that I was unlawfully detained based on these facts. A reasonable person makes conclusions off of facts. She or he makes rational, reasonable conclusions based on facts. All right. Plaintiff disagreed with Holyfield, Breland, and Doe's actions against him, but did not resist because fear of possible retaliatory criminal charges, excessive force, death, or all. You always want to put an affirmative defense in that, because you don't want them to try to argue that you consented to this. that you agreed with this, because they'll try to do that. Neither Holyfield, Breland, or Doe have filed criminal charges against plaintiff thus far. None of them did. After Breland was notified via dispatch that plaintiff had no warrants, the handcuffs were removed from plaintiff's wrist. See how simple this is? Plaintiff neither consented to be detained nor the seizure of his wallet. They took my wallet too. That is private property, and you took that without a warrant. You not only took private property without a warrant, you also detained me without reasonable suspicion. That is unlawful. You cannot do that unless you have my permission to do so. Mm-mm. Let's see. I was really slick with this. Also, I don't care who's violating your rights. If all of these officers are there and they're violating your rights, they have a duty to intervene and stop the other officer from violating your rights. But in the 11th Circuit, they have construed that as only to excessive force claims, meaning if the police officers are beating you up and there's other police officers that are in position to intervene and they see them beating you up, but they don't do anything about it, then you can sue them for that. But these particular officers, I amended my complaint and I took these allegations out, and I put something else in because as a matter of law, that particular cause of action, failure to intervene, would have failed. So I took that out, and I put this in. These are the other elements under on the Alabama common law and on the federal level. Holyfield, Breland, and Doe at all times herein acted under color of state law, graciously, willfully, and beyond their authority with the intent to injure plaintiff. And that is what they did. When I say injure, I'm not talking about like they broke my arm or something like that. An injury is the violation of a legal right. That's what an injury is. Let's see. Look how simple this stuff is, y'all. This stuff is so anybody can do this stuff, man. So I don't want to hear y'all saying you can't do this. But long story short, that'll be it for this document. Now I'm gonna go to the next document because a lot of people want to hear that you want to see their answer. So we'll go back and I'm gonna let y'all see their answer because they have to answer this complaint. So I paid the filing fee. Always pay the filing fee. I'm gonna tell you that right now. If you don't want them to screen your complaint for frivolity, because they're required to pursuant to 28 United States Code 1915, they're required, if you're trying to waive the filing fee, they're required to screen your complaint and to see if it has merit or to see if it is frivolous. Notice of filing, blah, blah, blah. Where's the answer? I'm going to get down to the answer. I had some issues with service on all my defendants, so that's why you see all of these documents. But soon you're going to see an answer. Boom, right there. See this? Answer to one complaint by Justin Holyfield. So Justin Holyfield, he answered the complaint first. His answer is 11 pages. So let's look at his answer. So what he did was all of the allegations that I made in my complaint, he is either going to admit or deny for want of knowledge. Something like that. If he admits it, like let's say number 3 he admitted. So whatever the fact was in my complaint for number 3 is no longer in dispute because he agreed that happened. And they're going to do that for every paragraph in your complaint. Every paragraph. So this one was the jurisdiction and venue, blah, blah, blah. It says the defendant is without sufficient knowledge or information to form a belief as to the truth of the allegations in this paragraph and therefore deny same. He knows this court has jurisdiction to adjudicate this. He doesn't think I know that. See, what he's trying to do is he's trying to milk his clients and he's trying to stall and delay. And we're going to go through discovery and he's going to test me to see what I know. That's what he's doing. He's trying to confuse me. This is a shotgun pleading, by the way. Same thing. He filed the same exact answer for Brandon Breland because Breland answered the complaint too. He filed the same exact answer. He just changed from wherever Justin's name was, he just put Brandon Breland. He filed the same exact thing. Parties. Defendant is without sufficient knowledge or information to form a belief as to the truth of his allegation and therefore denies same. Defendant admits that he was a police officer employed by the city of Chickasaw, but denies all remaining allegations in this paragraph concerning what times were relevant to the facts herein. Notice he denied that. He ain't no dummy, y'all. He ain't no dummy. So, number 9, upon information and belief admitted, defendant is without sufficient knowledge or information to perform. Look, he did this everywhere because the reason why he has to deny this because if he admits this, then we don't need a trial. I can motion for summary judgment, or I can motion for a judgment on the pleadings because an answer to a complaint is a pleading. And this is what he did all through my complaint. When he answered my complaint, this is what he did. If they do this to your complaint, that means you have filed a damn good complaint. And it's a 9 times out of 10, you're going to get a shotgun pleading. See this? All through the complaint. All through his answer, this is what he did. To the extent this allegation realleges prior allegations in plaintiff's complaint, the defendant reaffirms his answers as set out herein. My first call, denied. Plaintiff denies plaintiff is entitled to any recovery or relief whatsoever, including the relief requested. Affirmative defenses. Okay. When they plead affirmative defenses, they cannot plead affirmative defenses in a conclusory manner. They have to show facts in support on why they are alleging this affirmative defense. If they don't do that, they violate due process. Now, this is what I realized that they do over here in this circuit. Well, not this circuit. I'm gonna say in this district or whatever. We'll say that. This district. They allow them to plead in a conclusory manner affirmative defenses. But they will make them substantiate their affirmative defenses after discovery has ended. Once discovery is over with, then you can request defense counsel, whoever it is that you sued, you can request their attorney to substantiate, in other words, to provide you a factual basis in which she or he is basing each of their affirmative offenses on for their clients. You can do that. You can also file a motion to strike in answer to a complaint because an answer to a complaint is a pleading. You can strike affirmative defenses. For example, the complaint fails to state a claim against this defendant upon which relief can be granted. That is not an affirmative defense. But yet, here it is, right here in this complaint. That is not an affirmative defense. You can file a motion to strike that. In some district, U.S. district courts, they will strike it, or in some U.S. district courts, they will simply treat it as a denial to the allegations in your complaint. That's what they did in my case. I'm going to show y'all my motion to strike, too, because I filed a motion to strike because they just pissed me off with that shit. Because he filed 3 consecutive shotgun pleadings. Okay. Let's see. Plaintiff has failed to set forth any claim or any alleged facts that would tend to show that he is entitled to any relief against this defendant. That is not an affirmative defense. That's the same thing as this right here. It's the same thing as this. Same thing, y'all. Defendant denies that the injuries and damages allegedly suffered by plaintiff were the legal and proximate result of any act or omission on part of this defendant. That is not an affirmative defense. Strike. It's not an affirmative defense. Defendant reserves the right to raise different and additional defenses as discovery progresses. That is not an affirmative defense. It's not an affirmative defense. If you want to do that, then you can just file a motion for leave of court to amend your answer. That's not an affirmative defense. Defendant asserts the defense of statutory law enforcement immunity, including but not limited to under Alabama law pursuant to Alabama code, blah, blah, blah. I would have to go and read that. If I'm not mistaken, not common law, because you can see that statute. There's no statutes in common law. But that is an affirmative defense. However, he has no facts in support of how he came to the conclusion that his clients are entitled to that affirmative defense. Defendant asserts the defense of substantive immunity. It's not an affirmative defense. It's not relevant to this case. I don't even know if that's in the. I've never heard of that. It might be. It might be some sort of an affirmative defense, but it has to be applicable to the case. It has to be relevant to the case, and it's not relevant to this case. So if you can strike anything that is immaterial, irrelevant, scandalous, or legally insufficient as a matter of law, you can strike that pursuant to Rule 12F of the Federal Rules of Civil Procedure. Defendant pleads common law discretionary function immunity. I don't even know if that is an affirmative defense. I don't think it is. There's only two in Alabama that I know of. That's state agent. I think it's state agent immunity, and this one right here. This is not it. That is not an affirmative defense. Plaintiff claims are barred by the applicable statutes of limitations. See this? Now he knows that my complaint is not barred by statutes of limitations. He knows that. That's an affirmative defense, but it's applicable. It's inapplicable to this case. He just y'all should. This man he filed like 32 affirmative defenses. Plaintiff's claims are barred for failure to comply with the applicable statutes of non-claims. That is irrelevant to this case. Strike. Struck. Defendant asserts defense of qualified immunity. That's an affirmative defense, but it's legally insufficient as a matter of law on its face because you pled it in a conclusory manner. There are no facts in here. None. So how can I properly litigate this affirmative defense? Just look at this. Just look at this, y'all. This is what a shotgun pleading is. This is what they do. The complaint fails to meet the pleading standard required by Federal Rules of Civil Procedure and bail. Okay, if that's true, then why didn't you file a Rule 12b-6 motion to dismiss? This is also not an affirmative defense, by the way. Strike. Self-defense is affirmative defense. But that's irrelevant to this case because the facts just don't show that this was that they had any right to do whatever they did to me. Defendant pleads an intervening or superseding cause. Look at all this stuff, man. This is the type of stuff that they do, man. This is the type of stuff they do. The Alabama Constitution does not provide a cause of action for monetary damages. That's all they do, y'all. That's all they do. This is their attorney. Now let's get to. I'm not going to show y'all the other answer because it's the same thing. It's literally the same thing. It's just a different name on it. So after that, I met with their attorney after everybody answered their complaint. Let's see the answer. This is what I had to go and meet with their attorney right here. I'm gonna show y'all this document. Right here. I think it's this document down here. But I'm gonna read y'all this order, and it's gonna make sense to you then. 6 pages. All right. Let's go here first. All right. A preliminary scheduling order In preparation for the entry of Federal Rule of Civil Procedure 16B, scheduling order, the party shall comply with the following schedule pursuant to Federal Rules of Civil Procedure 26F and Local Rule 26. Meeting of the parties. The parties, including pro se parties, are ordered to meet and file a report pursuant to blah, 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 as soon as practical, but not later than October 11, 2021. The parties may, if the offices of their principal counsel are not within 100 miles of each of another, conduct the meeting by phone. The report of the parties shall conform to the court's format and comply with and a copy of which is attached to this order. The report is not included. The report is to include plaintiff's brief narrative statement of the facts and the cause of action stated in each count, and defendant's brief narrative of the facts and defenses, including affirmative defenses, stating the theory of each defense. In other words, the parties are to fully state their present respective positions in plain English, given what they know about the case at this time. This is not to simply read. This is not. Boy, I'm so tired, y'all. I get like this when I get tired. I'm sorry, y'all. This is not to be simply a restatement of the complaint and answer. Rule 26 disclosures. Required disclosures, blah, blah, blah. Y'all can read all of this stuff. I'm not going to read this. But basically, he wanted us to have a meeting. And in this meeting, we were going to discuss, let me see, commencement of discovery. We were to discuss discovery. Right here. Except as otherwise ordered by the court. Formal discovery under Federal Rules of Civil Procedure 30, 31, 33, and 34, and 36 may not be commenced before the meeting of the parties except in the following actions. Actions in which a temporary restraining order or preliminary injunction is sought. An injunction, I just told y'all, is an equitable remedy. Actions in which discovery is needed to resolve a preliminary motion, such as an objection to personal jurisdiction or venue. Okay, so those are the exceptions to discovery. So we're gonna go back, and then I had to meet with their attorney. Let me see what this one is, because I haven't looked at this document yet, so I want to see what it is. It's a one-page document. Oh, it's the same thing. Okay. All right, let's go back. Scroll down a little bit more. 21. Boom. Okay, here we go right here. So I had to meet with their attorney. I met him at his office. And while I was there, we were discussing the case, and I'm gonna elaborate on that for y'all. This is his narrative of the facts, whatever. Pursuant to Federal Rules of Civil Procedure 26F, a meeting was held on September 20th, 2021, and was attended by plaintiff Isaac Davis, David Walker for Justin Holyfield and Brandon Breland. The parties do not request a conference with the court before entry of a scheduling order on this case. That's his version of the facts. Let's see. We also talked about, how many days would we need to select the jury? Okay, I thought it was, this is my first time doing this, so I was under the impression that, we would probably need maybe a week. But he was like, no, he doesn't think it's going to take that long. So to a certain degree, I considered everything that he said because he had been litigating this longer. He had been litigating lawsuits longer than me. So he says 2 days. I'm like, cool, 2 days. Okay, whatever. Plus, if we need more time, then we can always, go to the judge, present this issue with the judge. Like, hey, we need more time. And then I'm sure that this particular judge, because he was pretty good in my opinion, he would grant it. Okay. The parties request a pretrial conference in August 2020. Discovery plan. The parties jointly propose to the court the following discovery plan. Discovery will be needed on plaintiff's factual claims, including but not limited to the events that occurred on the night in question and damages and injuries claimed by plaintiff. Discovery may commence upon the filing of this report. So, meaning, um, because we had talked about it at the meeting when we were going to do discovery. He was like, "Well, we can do discovery after we hold this meeting." I'm like, "Cool," because I wanted to do discovery right after the meeting anyway. All discovery commenced in time to be completed by May 1st, 2022. So we had about 6 to 8 months of discovery. So you have about 6 to 8 months to get all of the evidence that you need. Initial disclosures. The parties will exchange by October 6, 2021, the information required by Federal Rule of Civil Procedure 26A1. The parties request until October 15th, 2021 to join additional parties and amend the pleadings. Reports from retained experts under 26A2 due. So, like if you wanted to get an expert witness or something like that, then that you had to it had to be due. Mine's had to be due January 3rd, 2022. Theirs February 1st, 2022. Pretrial disclosures. Final list of witnesses and exhibits under Rule 26A3 due August, blah, blah, blah. Discovery limits, okay? Uh, the rules that I read you, I think it was 31, 32, 33, 34, and I think 36. Those are all in the Federal Rules of Civil Procedure. Those are all instruments and tools that you would need for discovery. Interrogatories, requests for admissions, what was it? Request for production, um, thing, and deposition, stuff like that. But anyway, discovery limits: maximum of 30 interrogatories by each party to any other party. Responses due 30 days after service. So this meant that the judge changed this stuff. Obviously, he issued an order after we had this meeting. The judge did. So you only get 30 interrogatories. That's it. And they have to either answer them if they're relevant. If they're not relevant, they don't have to answer them. Something like that. A maximum of 30 requests for admissions. A request for admissions is like if you alleged in your complaint, you say that they arrested you without a warrant. In your request for admissions, you would say, admit that you didn't have a warrant on the night that you arrested me. And they would either admit it or they would deny it. On to the next. Maximum of 30 requests for productions. Request for production of documents. So a request for production of documents is it? You send them a request and you're requesting whether it be videos, any type of documents that they tend to use against you, any type of documents that you tend to use against them, stuff like that. Maximum of 8 depositions. Deposition is where you go to a building, you swear in like you're in court. There's probably a camera in there. There's going to be a court reporter in there, and there may be 2 other witnesses or something like that. And the attorney, he basically cross-examines you while the court reporter is in there typing down everything. That's it. Let's see. A 5-day written notice of intent shall be served on all parties prior to the issuance of a non-party subpoena seeking the production of documents and things, blah, blah, blah. All potentially dispositive motions filed by June 1st, 2022. So a dispositive motion is a motion for summary judgment or a motion to dismiss, something like that. That's what a dispositive motion is. Settlement cannot be evaluated prior to completion of discovery. That makes sense. Other matters, blah blah blah. Let's go. Now I'm gonna go to the scheduling order that the judge issued after we had this meeting. Let's go here. Report meeting to Judge Murray. Here it is, right here. 21 pages. You know what? This is really getting long. I think I'm gonna do a part two to this because this. Let me see how long this video is right now. It's about 44 minutes. I'm gonna do this document and then that'll be it. We'll stop after that. So we'll view selected. I had to get me something to drink, y'all. Okay, this right here is called obviously a Rule 16B scheduling order. uh this order right here, y'all, you're going to get a copy of this order. They're going to get a copy of this order. This order, uh, until the trial is over with, will govern your trial. So if you deviate from this order in any way whatsoever, the court will sui sponte strike whatever it is that you're trying to do if you're not following this order. You'll strike it. That's what happened to me a couple of times in my case. After consideration of the Federal Rules of Civil Procedure 26F report, Doc 21, filed September 22nd, 2021, and the comments of pro se plaintiff and defense counsel during scheduling conference of October 6, 2021, the following schedule order is entered pursuant to blah, blah, blah. Final pretrial conference. They're telling you everything that's going to happen. Everything. Your dates, time limits, all of this stuff is very, very organized. It's very organized. Trial dates, final pretrial conference, trial dates. You see all your dates in here? Discovery. See this? It's very organized, y'all. Who is this? Somebody calling me. I don't know who that is. Amendments to pleadings right here. So if I wanted to amend my complaint, I had to do it before this date right here. Motions for leave of court to amend pleadings or to join other parties must be filed no later than October 15, 2021. If you try to do it after this date, you're likely you won't get it. There's a strong possibility that you probably wouldn't get it because you should have been dead. Expert testimony, all of this stuff. They cover everything, y'all. Everything. Pre-trial disclosure, discovery limits. So if y'all read the other one, the other document, it said one set of interrogatories, one set of 30 interrogatories. But the judge, he didn't think that was enough. So he said two sets of interrogatories, not to exceed 30, basically, right here. Discovery is limited as follows, and he has a footnote right here. Those specific discovery issues identified by the parties in paragraph 4 of their joint Rule 26F report, Dr. 21 page, are the issues subject to discovery in this case. That's it. If it's not in that report, they are not subject to discovery in this case, and you can't get it. They're not going to give it to you. Not more than two sets of interrogatories, not to exceed a total of 30, including all discrete subparts, may be served by each party upon any other party. Responses are due within 30 days of service. So you got to return that stuff in 30 days after you get it. Or some of that stuff they'll deem it admitted, like in a request for admissions. They'll deem those admitted if you don't answer. They'll sanction you and you'll just deem them admitted. Not more than 8 depositions. There you go. What else? Not more than 2 sets of requests for admissions, not to exceed a total of 30. Blah, blah, blah. Not more than 2 sets of requests for. So basically, the judge said you get 2 sets of 30s of everything. That's it. Nothing else. That's it. Discovery motions. The following requirements pertain to discovery motions and similar non-dispositive motions in this court. Conferencing by counsel. The conferencing required set forth in the Federal Rules of Civil Procedure shall be strictly enforced and govern any motion by any party to obtain either court facilitated discovery or protection from any other parties from another party's attempts to obtain information through discovery, and any motion for an extension of time of discovery related issues. This requirement applies to all such discovery related motions, including but not limited to those referred to in 26C motion for protective order. I'm not going to read all that, but uh, all this. He covers everything, y'all. When you get this order back, when you get this order from the judge, you need to carefully read this order and make sure you understand everything in it, because this will guide you into to also successfully prosecuting your case. That's what you need to do. Make sure you got it. What is that? Is that a footnote? Yeah, he did. Motions with certifications lacking this level of detail will be stricken. So some of this stuff, yeah, he gonna strike some of this stuff. June 1st. There was something else I wanted to talk about in here. I think listen, this video is kind of long. How long have I been on here? So I got about 9 more. I was gonna do one for about an hour. So I got about 9 more minutes. So what I'll do, I'm gonna stop right here. That'll be the end of this video. Let me see what else. What has he got in here? Oh no, that's the district judge who was over the case. This is her standing order. Okay. All right. So I'm gonna stop right here. I just wanted to give y'all an idea of what this stuff looks like. This order right here. When you get this from court, you're gonna get this right before discovery starts. At least that's when I got mine, right before discovery started. This order is going to dictate how the trial and everything is going to go. So you need to make sure you read this order and you understand it. Let's go back here. There was, let me see, reporter answer. Okay, notice of filing recorded motion to strike defendants from defendant motion referred. Yeah, I did file. Yeah, I filed a motion to strike Brandon Breland's affirmative defenses. I did. I think I withdrew the motion after we had a conference call. Let me see. I withdrew it from somewhere. I'm trying to find it. I can't find it. This motion is strike defendant affirmative. Well, this is an order. This is a report and recommendation on my motion to strike, doc number 45 right here. I filed a motion to strike his affirmative defenses. I actually filed two, but I withdrew one of them. But when he filed that third one, I just got tired of it, and I filed a motion to strike. So I'm going to go over my motion to strike a little. How much time we got? About 7 more minutes. It's about 11 pages. Okay. View documents. Motion to strike. Comes now, Isaac Davis. Hereinafter plaintiff, pursuant to Rule 12F of the Federal Rules of Civil Procedure, to strike Justin Holyfield's and Brandon Breland's hereinafter defendants' affirmative defense. Hereinafter AD. So the affirmative defenses are going to be called AD. 1 to 28 of Doc 44, page 5 through 9, as either insufficient, immaterial, impertinent, or improper. In support of this motion, plaintiff states the following grounds. So he really pissed me off when he did this, y'all. In fact, I have an email from him threatening to sanction me because he wanted me to withdraw my motion to strike because he didn't want to pay his paralegal um, for drafting a response to my motion to strike, and I ain't withdraw it, so he'll be all right. I know for a fact that this motion to strike is not frivolous. Plaintiff averse defendants have now placed the onerous task on the court and plaintiff to sift through pages of vague and conclusory averments of a shotgun answer to determine the grounds defendant might have intended to form a basis for each of their defenses. This motion to strike is remedial to said task. Plaintiff avers in the absence of binding precedents, it is inequitable to hold him, a pro se litigant, to a higher pleading standard than that of learned counsel, David Walker, a practicing attorney for over 20 years. In other words, it is not fair to require plaintiff to provide defendants with fair notice that there is a plausible factual basis for his cause of actions, but permit defendant under a lower pleading standard than fair notice that allow defendants simply to aver their affirmative defenses in a vague and conclusory manner because it is insufficient, since it does not provide notice sufficient to allow plaintiff to rebut or properly litigate the defenses. Last, in considering said motion, the court ought to sui sponte sanction counsel or at least strike counsel's answer in entirety and instruct counsel to replead his answer, since this is, in fact, emphasis added, counsel's third filing of a shotgun answer, which counsel knew or should have known or consistently condemned within this circuit and has been for at least 30 years. He knows that. He pissed me off. Legal standard. You always have to cite the legal standard. The court already knows the legal standard, but they're going to want you to cite it. They ain't going to want to do your work for you. So make sure you cite it. Rule 12F provides that the court may strike from a pleading an insufficient defense or any redundant, immaterial, or impertinent matter. Rule 8B's general pleading standard applies to affirmative defenses, which requires a party to state in short and plain terms its defenses to each claim asserted against it. Thus, the court reviews affirmative defenses to ensure they provide fair notice of the nature of the defense and the grounds, in other words, the reasons upon which it rests. It is plain that the purpose of Rule 8C is simply to guarantee that the opposing party has notice of any additional issue that may be raised at trial. Purposes of Rule 8C is simply to guarantee that the opposing party has notice of any additional issue that may be raised at trial. Motions to strike affirmative defenses are generally disfavored. It is well settled. It is well established that the action of striking a pleading should be sparingly used by the courts. It is a drastic remedy to be resorted to only when required for the purpose of justice. However, affirmative defenses which fail to satisfy Rule 8B should be stricken if they fail to include more than bare bones conclusory allegations. Now, there is no 11th Circuit precedence on this. So the judge, he pretty much can rule any way he wants on my motion to strike. And that's exactly what he did. Hold on, y'all. Give me a second. Let me get something to drink. Right here. Affirmative defenses must amount to more than mere conclusions of law. A court should also grant a motion to strike a defense as legally insufficient as a matter of law when, 1, on the face of the pleadings, it is patently frivolous. Patently means clearly frivolous. Clearly, it is clearly frivolous. Or it is clearly invalid as a matter of law. Let's go down a little bit more. Right here. So the first affirmative defense. Plaintiff avers defendant's AD1 is nothing more than a vague and conclusory denial of plaintiff's prima facie case, and therefore legally insufficient as a matter of law because it is not an affirmative but negative defense. A defense which points out a defect in a plaintiff's prima facie case is not an affirmative defense, and it's not. It is not an affirmative defense. This is where he reserved his right to amend his answer. And he cited this, and he tried to make it seem like it was an affirmative defense. It's not an affirmative defense. Plaintiff avers defendant's AD2 is legally insufficient as a matter of law and should be struck as patently frivolous because it is not an affirmative defense and it circumvents Rule 15 of the Federal Rules of Civil Procedure, which allows defendant to move for leave to amend a responsive pleading. Plaintiff avers that defendants AD 3 and 5 are legally insufficient as a matter of law and should be struck as improperly pled because defendants brought forth, this is how you plead an affirmative defense, y'all. I'm about to tell y'all. Defendants brought forth no other facts whatsoever for justification or avoidance to properly establish the affirmative defenses of 1, state agent immunity, and 2, immunity granted by Section 65338 of the Alabama Code 1975, but merely averted in a vague and conclusory manner that renders it a shotgun pleading. This hinders plaintiff from rebutting and properly litigating these defenses because defendants fail to give plaintiff fair notice of the defenses, the grounds upon which they rest, and how it applies to this case. And they have to do that. But they still divided on the circuits. In one circuit, they might let you plead an affirmative defense in a conclusory manner. In another circuit, they might not let you plead an affirmative defense in a conclusory manner. This is why I want to get these books out to y'all. That's why I'm trying to do this circuit series books. And I need y'all help to help me finance this. Because if y'all want me to do this, I'll do it for you. Okay, but that's the only thing that I want to focus on. I don't want to focus on anything else except for these books. That's it. Plaintiff avers defendant's AD4 is legally insufficient as a matter of law and should be stricken as patently frivolous or clearly invalid as a matter of law because Alabama law only recognizes 2 types of state law immunity. 1, state agent immunity, and 2, discretionary function immunity. Common law discretionary function immunity does not exist under Alabama law, and it does not. He made that shit up. Assuming arguendo said immunity did exist, it should be struck. It should be stricken as improperly pled, whereas it too hinders plaintiff from rebutting and properly litigating this defense because defendants fail to give plaintiff fair notice of the defense, the grounds upon which they rest, and how it applies to this case. And they just keep doing it, y'all. They just keep on doing it. Here's another one, number 7. Plaintiff avers defendant's AD7 is legally insufficient as a matter of law and should be struck as patently frivolous, immaterial, and impertinent because it is only applicable to cases dealing with the estates of decedents, and this is not that type of case. And he still pled this as an affirmative defense. That is legally insufficient as a matter of law, and it should be struck. It should be struck as patently frivolous, immaterial, and impertinent. It is not relevant to this case. This is how they do, y'all. This is how they do. So y'all can just get ready. If you file a prima facie complaint, this is how they gonna answer your complaint. That's how they did it in my case. Excuse me, I had to stretch, y'all. Well, we had 63. Well, most of my arguments to strike these affirmative defenses, they pretty much the same because he pretty much did the same thing in all his affirmative defenses. That's pretty much what he did, y'all. Let me see. Try to find something that's new. He pretty much did the same thing, y'all. I ain't gonna lie. He just copied and pasted. That was it. Here's another one right here. Plaintiff avers defendant's AD12 is legally insufficient as a matter of law and should be struck as patently frivolous, immaterial, and impertinent because it is only applicable to a city or town, and defendants are neither a city nor a town. I didn't sue the city. I didn't sue a town. Right there. Second, plaintiff avers defendant's AD13 is legally insufficient as a matter of law and should be struck as patently frivolous, immaterial, and impertinent because it bears no connection to any cause of action, affirmative defenses, or parties to the instant action at all. And what are you talking about? But this is what they do, y'all. This is what they do, man. So y'all got to know how to respond to this. Whenever they file an answer to your complaint, and it's vague and it's concluded and it's confusing, you see a shotgun pleading violates, I think it's Rule 8 and Rule 10 or 7 in the Federal Rules of Civil. It's 2 or 3 rules it violates. The whole purpose of these rules is to prevent stuff like this from happening. And he's violating these rules when he files this shotgun pleading. And that's why you got to strike it. File a motion to strike, even if it's going to be denied. You're going to cost him money. You're going to cost him because he has to pay a paralegal to type his responses up. That's what they had to do for my case. Let me see if I can find that email for y'all right quick. Give me 1 second. When he threatened to sanction me because I filed this motion to strike. Give me a second. All right, y'all, I'm back. All right, this is the email right here that I was telling y'all about. This is the email that he was threatening to sanction me if I didn't withdraw my motion. Because I haven't read this yet, but it looks substantially similar to the prior motion to strike that you filed. The judge talked about this. The judge talked about that with us on the phone for a long time, and you agreed to withdraw that prior motion to strike. Yeah, he's right. I did. But you filed another damn shotgun pleading, man. You did this 3 times. 3. I agreed to withdraw one of the motions, not all them bitches. Why are you filing this again? As we have discussed over and over again, you don't have to do anything to disprove my affirmative defenses. Not at this point, I don't. And on the other hand, if I do not raise an affirmative defense, then I run the risk of waiving it. He's right, but that ain't my problem. That's your problem. I won't go through this again. Everything that we have discussed about affirmative defenses, I am not placing an onerous task on you or the court. Instead, you are placing a burden on me and the court to address a motion to strike that is meritless. If it's meritless, then why you even answer the motherfucker? If it's meritless, why you ask me to withdraw it if it's meritless? I'm going to show y'all his response to my motion to strike too, by the way. And which you have already discussed with the court and with Drew. This is the first time in my 27 years of practice that a plaintiff has moved to strike affirmative defenses. I'm not one of your attorney friends, man. I'm not. We're not doing that. I don't have a client that's paying me, and if I did, I still wouldn't do that. That's what you do, not me. Plaintiff please withdraw this motion, or I would have to spend time drafting and filing a response. Well, go ahead. And I may seek sanctions myself as you request in your motion. Okay, we'll do it. Because I know 100% for sure that this motion to strike is not meritless like he's saying. I know it ain't. Because I did my research. That's why when I filed this motion to strike, the judge did not sanction me at all. At all. I was right about a lot of the stuff that I said in my motion to strike, y'all. But you know, when you're a pro se litigant, they don't want to give you no type of respect because they don't want you to know that you know what the hell you doing. They be hating, man. Y'all also don't email this guy. That's his email address, but don't email him. Okay. He's just doing what he's doing for his clients, what he always do, but he got the wrong one. At the end, you know, when the case was over and we settled the case or whatever, we shook hands and he told me I was a worthy adversary. You know, so we're good. But I think this video has been long enough. I go back. I do a part 2, probably tomorrow or something, or I don't know. Whenever I have time, I'll do a part 2 and go over this stuff with y'all. If you need a live Q&A, let me know, and I'll try to schedule one as soon as I can. But that'll be the end of this video. The Supreme Litigant is out. Peace.